Yes, Mr. Weaver.
My Lord. Addressing first a point that my Lord Justice Phillips raised yesterday with respect to the sales figures. Just for your note, this is paragraph 8 of Mr. Watkins' witness statement, which may be found in the supplementary bundle behind tab 23 on page 74. There's only 2 years for which there are complete sales figures.
Is it worth having a quick look at that?
My Lord, it's tab 23, page 74. So what we've done is total the values for 2021 and 2022. And for 2021, the total is 26.6 million.
Right.
And for 2022, the total is 27.1 million. I've rounded those figures to the nearest decimal point.
Fair enough.
You can see the difference is about £500,000, but the sales of the Cloudy Lemon product were about 1.6 million, and so therefore, in direct answer to my Lord's question, there is cannibalisation.
Okay.
So, if I may, I was going to slightly recap with respect to the transfer of image and then move on to some of the other cases on transfer of image. This necessitates, in part, consideration of intention. You'll see why, because of course some of the cases
as the debate at the end of yesterday revealed, yes.
Yes. So therefore, this is not a pure transfer of image heading, if you see what I mean. I'm giving you that as a forewarning.
Yeah, that was where I was at cross purposes with you yesterday afternoon.
Yes.
Because I thought you were just talking about transfer of image, when in fact, as you made clear, you were talking about both, and understandably so in retrospect.
Yes, well, I'm sorry I didn't make that clear to start with myself. But anyway, might I, so to speak, start off with the transfer of image, and then I'm going to, I'm afraid, sway into intention, and then I'm going to address attention purely right at the end, if you see what I mean, because that's a slightly different consideration when you view it in isolation. And the starting point is the way in which this was pleaded, and you can see that from the particulars of claim, which is in the core bundle behind tab 9, and it's at page 166. And the relevant paragraph is paragraph 20, which starts on the previous page, and 20 subsection B is talking about a link, and then subsection C, which is on page 166, talks about the riding on the coattails, and so of course that's an allusion to unfair advantage. And then in D, this is where you get mention of the phrase transfer of image, but this is in the context of dilution. So subparagraph D, the defendant's use of those graphics will result in the dilution of the distinctive character and or repute of the trademark, in that the ability of the mark to identify the goods for which it is registered will be weakened. It will cause a transfer of image from the Thatchers product and the trademark to the Aldi product and its appearance in the minds of consumers.
Yes,
and
but
it goes on.
These various sub-paragraphs, I presume you would accept, are rolling all three things together.
Yes.
You can't find a discrete plea in relation to each of the three injuries.
No, but I was giving you the context in the way in which it was pleaded, and it arose, so to speak, in 20 subsection D.
Well, but what about C, where it says at the end to exploit the marketing effort expended by the claimant to create and maintain the images? I take it that's a typo, but the image of that mark. So there's a reference to image there.
My lord, yes, but I was focusing upon the actual phrase transfer of image because that's the phrase that turns up within the L'Oreal case. So I accept your point that within paragraph 20 of the particulars of claim and the 4 sub-paragraphs, they cover off all the bases, but the way in which it expressly turned up, the actual phrase, the 3-word phrase, transfer of image, was in that the 4th paragraph.
But why does it matter? Because there's a clear allegation of transfer of image, is there not?
Yes, but it was brought up, my lord, in the context of dilution. And the point is the way in which the pleadings are set up then determines the way, or at least has some determination of the way in which the case is run.
Well, I could understand that submission if we had watertight pleas of unfair advantage, firstly, secondly, dilution, and thirdly, tarnishment. But when we look at this, as he's already accepted, we don't find that.
No.
It's all mixed together.
Yes, but any division that you could make on the face of the pleadings would be that it's more naturally, in the way in which it's being pleaded, focused upon dilution. There's no hard and fast lines. I accept that, my lord. What I am saying is that on the balance, the way in which the point was put forward was in that context. But
Right.
in any event, there was a reference in the claimant's trial skeleton. This was the paragraph 80, which was referred to in footnote 19 of the appellate skeleton.
Right, we have that.
Yeah. So you'll find that in the core bundle, behind tab 3, page 34. That's where the 19th footnote is.
So we don't have the original.
Oh, sorry, we do have the original, but
Well, it might be. Since you've just made a point about context, let's see it in context.
Page 213, behind tab 11.
Thank you.
Now that is in the context of change of economic behaviour, but it is there. You need to go back 3 pages to page 210 of the core bundle, under the heading of unfair advantage.
Right.
And you can see that there's a difference, because if you turn the page to 214, there's another subheading which is detriment.
Yeah. So in this case, you're accepting that transfer of image is squarely within the context of unfair advantage.
Well, yes. Now, the phrase, as we know, had its genesis in the Court of Justice in L'Oreal. And so I thought it was appropriate to go to that next, if I may. You'll find that in the 4th authorities bundle. Behind tab 35. And we will pick it up at paragraph 41, which is on
Yeah,
page...
just before we get
Sorry.
to that, can I ask a question?
Sure.
And this is a genuine question, because I haven't got around to checking yet. Everybody always cites paragraph 41, and as I was commenting yesterday, there's a bit of further light shed by paragraph 49 in the judgment. Is there anything useful that we can get out of the Advocate General's opinion on this?
Well, Yes and no, in some senses. I'm sorry about that answer.
Right.
Yeah, my apologies, that's not very helpful. If you go to the AG's opinion, in particular, AG paragraph 65, which is on page 1483.
Yeah.
It's quite a long AG's opinion, and it's quite a short judgment, if you see what I mean.
That's not uncommon.
But you can see there's lining, which goes on for many pages, through to paragraph AG 80.
What would you say about, before we get to that, to the general point that the Advocate General makes in paragraph 71?
Well, that's a completely general statement with which I would agree, but I would have thought also my learned friend would agree, because it basically just says you need to take into account everything. If I've read the, if we're referring to paragraph 71, yes.
Applied in a flexible manner in a case-by-case basis in the light of the factual circumstances of this case. In other words, the point he's making is that the legislature has seen fit to create a harm which is expressed to be unfair advantage without giving any guidance in the legislation as to what is to be considered unfair versus fair. And the point the Advocate General is making, based upon the submissions both of the Commission and the United Kingdom, is that it must follow from that the burden is cast upon the courts to decide what is unfair and what as opposed to fair.
My Lord, I would agree with everything you said. If I may, I would add a nuance to that, and that is that my lady and my Lord Justice Phillips, please forgive me, because we need to delve back a little bit into the history of trademarks. In the United Kingdom, my Lord Justice Arnold knows this better than I, under the old Act, the 38 Act, you could only in essence have infringement with respect to identical goods or identical services eventually. Under the directive, which from which the 94 Act originates, the scope of infringement was widened. So we've already seen that section 10.1 is identical, 10.2 is identical, similar, but 10.3 used to be you needed some identicality or similarity of the mark and the sign, but it only applied to dissimilar goods or services. You'll notice that in the version that you've got behind tab 3 in Authoritative Bundle 1, I think it's page 19, that actually a whole part of section 10.3 has been deleted because, according to the jurisprudence of the Court of Justice, that dissimilar requirement for goods or services was removed.
Well, to be clear, they interpreted the words to mean even if dissimilar.
Yes, the Court of Justice interpreted the words dissimilar to mean identical, similar, or dissimilar. And the United Kingdom thought the easiest way of dealing with that was to delete the dissimilar bit within section 10.3. Now, the reason why I've said all that is because that showed a significant expansion in the way in which an infringement could occur under the 1994 Act, which is predicated upon the way in which...
All of that's true, but I don't understand the relevance of that.
Well, I was laying the groundwork, my Lord, because you know more about this than the...
Well, indeed so, and you know, this is a court of three,
yes.
And you can't pitch all your submissions to me, but if you're going to explain the history, you have to then say why is it relevant?
Because the submissions that were made, in particular by the United Kingdom government, with respect to the L'Oreal case, must be read in the light of the way in which matters occurred originally in UK. And so therefore, in my submission, the way in which the UK was putting, I wasn't the...
Sorry, are you saying those submissions were made before the amendment of 10.3? When?
No. But the point being is, it's still in the light of the fact that the way in which the Europeans consider infringement is much wider than the way in which it was considered previously in the United Kingdom.
I'm sorry, but if you're going to start doing that, we have to have a bit more fundamentals here. So the starting point here is that the Trademarks Act of 1994 had two key purposes, and I don't think you can establish a hierarchy between them. Firstly, and most obviously, it was to implement the first Council directive on trademarks, which was the first harmonising measure. And so the United Kingdom as a member state was required to implement that directive, and that was the first purpose of the 1994 Act. But if you look at the white paper that preceded the 1994 Act, it is very clear that it was recognised that the United Kingdom needed a new and up-to-date trademark law anyway, because the 1938 Act was notoriously badly drafted and was generally regarded as being no longer fit for purpose. So it was a clean start, albeit retaining inevitably, because we're dealing with trademarks, a lot of concepts that at least at first blush appear to be similar, but upon further examination turn out not necessarily to be the same.
And moving on from that, my lord, is that the scope of the 10.3 infringement was much wider than that which went before.
Well, it was in some respects, but of course we did have importing a reference under Section 41B of the 1938 Act.
Yes.
And, to start explaining that,
well, I'm not going to, full stop.
Takes too much time.
Yes. What I was trying to get to the point was that the United Kingdom, when it was making submissions to the Advocate General in the L'Oreal case, well, it would be the full court, but recorded by the Advocate General, would in essence be in the context that the wording in 10.3 is very wide. And so therefore it would be natural for them to say words to the effect that it must be applied in a flexible manner on a case-by-case basis in the light of the factual circumstances of each case, and i.e. it would be judge-led as to how it would actually operate in practice.
Yeah, all right. So, is there anything more on the question of, particularly this question of transfer of image?
Well, I was going to go back to the judgment, if I may.
But
Sorry.
Where all this started was my question as to whether the opinion of the Advocate General shed light on the notion of a transfer of image.
Not expressly. But
the Advocate General does consider the concept, though. I think, on misreporting. I assume that's in this sideline passage.
I might be wrong, but I don't think the Advocate General actually uses the phrase transfer of image. And we can word search it.
But this passage is answering the third question. So are we indeed looking in the right place?
Well, yes, that's another point.
What does he say about the fifth question?
Well, that starts at AG 90 on page 1489.
Yeah, so in paragraph 99, he cites previous case law referring to transfer of image.
Yes, it doesn't uses the phrase risks that the image of the mark are transferred.
Yeah, all right. Well, none of this has been sidelined, so I take it that nobody thinks that this is particularly of assistance.
So, if I might go back to the main judgment.
Yeah, all right, thank you.
41 is where we all start, because that's where this actual phrase, forward phrase, comes, transfer of the image. If you go to the bottom of that page, that's 1502 I'm on, paragraph 44, in order to determine whether the use of a sign takes unfair advantage of the distinctive character or the repute, it is necessary to undertake a global assessment, taking into account all factors relevant to the circumstances. So that echoes some of the comments in the AG, admittedly in respect of question 3, which include the strength of the mark's reputation and the degree of distinctive character of the mark, the degree of similarity between the marks at issue, and the nature and degree of the proximity of the goods. It carries on in like vein. If you turn the page, it is also clear from the case law that the more immediately and strongly the mark is brought to mind by the sign, the greater the likelihood that the current or future use of the sign is taken or will take unfair advantage of the distinctive character or the repute of the mark, or is or will be detrimental to them. Then in 46, this paragraph was drawn to your attention yesterday because this talks about the fact that you're talking about a case here of imitations. And then in 47, this is important because it says, in that regard, the referring court has held that there is a link between certain packaging used by the defendants on the one hand and certain marks relating to packaging and bottles belonging to L'Oreal on the other. In addition, it is apparent from the order for reference that the link confers a commercial advantage on the defendants in the main proceedings. It is also apparent from the order for the reference that the similarity between those marks and the products marketed by the defendants was created intentionally in order to create an association in the mind of the public between the fine fragrances and their imitations, with the aim of facilitating the marketing of those imitations. So there's a finding of that the reference is predicated upon a number of facts. Of course, the Court of Justice can't go behind that finding or those facts as stated in the reference. So there's a link, there's a commercial advantage, and it was created deliberately. And therefore, when you get to 49, in that regard, where a third party attempts, through the use of a sign similar to a mark with a reputation, to ride on the coattails of that mark in order to benefit from its power of attraction, its reputation and its prestige, and to exploit without paying any compensation and without being required to make efforts of its own, etc., etc., the advantage resulting from such use must be considered to be an advantage that has been taken unfairly. And so the point about this case is that it was predicated upon the fact that there was an advantage, there was a link, and that link had been created intentionally. And so the case only focused upon whether or not, in those circumstances, that amounted to unfairness.
Well, the dispositif, which is the bit that matters, is expressed in general terms. It's not saying we find that there's unfairness on the facts of this case, is it?
No, my lord, but it must be predicated upon the facts of the reference.
It's an interpretation of the legislation. Article 5.2 of the directive must be interpreted as meaning that, and so on.
But predicated upon the facts of the reference. I mean, that's the way.
So this is a case about smeller-likes, all right?
Yeah.
Are you suggesting that the ruling is confined to smeller-likes?
I'm suggesting, my lord, that it's confined to a case concerning imitation.
But on one level of generality, the judge
Yes.
in our case found that your client's product was an imitation. She didn't use the word,
Well,
but that could be regarded as a succinct summary.
No, my lord, I would actually strongly resist that analysis.
I mean, the dispositive obviously needs to be interpreted in the light of the reasons in the judgment.
Yes.
But the reasons, although it is a case of imitation, the reasons are not founded on that, on my reading at the moment.
Well,
And if it was, then I would have actually expected that to be reflected in the dispositive as well. I'm just reading the dispositive again.
well, it's predicated upon there being an advantage.
Well, seeks that use, which arguably means intention, seeks by that use to ride on the coattails of a mark with a reputation in order, again, implies intention, to benefit from the bad attraction, reputation, etc.
And my lady, I would say that though that language, that seeking language, imports the finding of fact that there was an intention.
Yes, but you're making a difference. I can see a point that the conclusion might be limited, appear to be limited to cases of intention. I mean, that doesn't mean the should add that the CGAU was saying that those are the only circumstances.
No, I'm not saying that either.
But I can't see your point about imitations in there.
Well, the point about imitations is that the whole point of an imitation is that it does seek to imitate.
Well, that isn't surely
Yes,
the
but-
only circumstance.
But the problem,
No.
the problem with that is it all depends upon what you mean by imitation. So the context of that case was that they were smeller-likes, and the purpose of imitation was to convey to the consumers which famous perfumes the substitutes were supposed to be imitating.
Yes.
Now, of course, in a lookalikes case, the purpose of the, let's avoid the word imitation, but the purpose of the resemblance is to convey to the consumer this is a cheaper version from a different source of a product with which you are familiar.
No, my lord, I wouldn't accept that for the following reason.
Well, why on earth does your client spend all the money on imitating the packaging?
Because, Lord, the mere fact that something looks alike something else does not necessarily mean it's trying to imitate in any shape or form.
Well,
It
okay,
might be.
Let me again avoid the word imitation. I apologise for putting that in my question again when I was trying to get away from
It's all right.
it. That wasn't what I meant. But as we can see from the work of the design agency, the reference point was the Thatchers product, and it was the only reference point. And this is where we get into the question of what is the purpose of the legislation? Because from your client's perspective, there's absolutely nothing wrong with what they're doing. They're simply giving consumers a helpful message. You know about the Thatchers Cloudy Lemon Cider product. You can get from us a similar product, which is not from Thatchers, and we will offer it to you at half the price.
See, my lord, in my submission, that is actually importing two things. The first is that just objectively it looks alike. The second thing is you're trying to form a link. By the very way in which you're phrasing that question to me, you're saying...
But the judge has found that there was a link.
Yes.
But there was no intention... Sorry, let me backtrack on that. What I'm trying to argue is that lookalikes per se, there's nothing wrong with that.
Well, indeed. That was the proposition I was putting to you. But the question then is...
Sorry, my lord, because it seems to me...
What is the test that we are applying?
Well,
where do we draw the line between competition for the benefit of the consumer and taking unfair advantage?
yes.
And that, surely, is precisely the question that the Court of Justice was addressing in this passage, albeit in the context of smellerlugs.
Sorry, my lord. The way in which I'm arguing this in response to my learned friend's appeal, as opposed to the way in which I was going to put it forward in the respondent's notice, because it's a slightly different emphasis, is that here, with respect to L'Oreal, what one is looking at is there's already a finding that there's an advantage, and the whole question of L'Oreal is whether or not that advantage is unfair. And the way in which L'Oreal decided it was unfair is because there was a finding of intention, or to use the wording that was in the dispositif, they were seeking a certain outcome.
Well, I would understand that submission if you were going to submit to us that intention was a crucial element. But you made clear yesterday that that's not your submission.
That's right, because there are occasions when intention doesn't arise and they may still be an unfair advantage. So that's why I answered that
Well,
question.
indeed, and you may intend it and fail. So, I mean,
Well, that's
why
true.
intention should be regarded as crucial is a bit of a mystery.
Because if it is there, then it can make clear that that which you're striving to do is unfair. So
Right, so would you agree with Mr. Howe's submission that the relevance of intention is evidential?
broadly, yes.
Thank you.
And that's why in this case, intention tipped it over into unfairness. There's an advantage which was taken with intention, and L'Oreal says that that's unfair. That's the reading. Sorry, my lady.
I thought Mr. Howe was also submitting that in a 10.3 context, intention could go beyond the evidential.
Yes, he was. But in answer to my Lord Justice Arnold,
But the starting point is it's evidential.
Yes.
Yes.
And it may...
So I'm just...
Yes, and yes.
So does it go, insofar as Mr. House submits it goes beyond being evidential, what's your response to that?
In the sense, if it goes beyond being evidential, i.e. it is, in essence, a mala fides act, if I understood him correctly, he didn't use that terminology.
No, well, and the court doesn't either.
No, but the point being is there was a deliberate seeking of trying to take an advantage. And the way in which I understood my learned friend's argument yesterday was that to start with, that can help evidentially, but also it could form a constitutional plank, so to speak, with respect to whether or not there is unfair advantage when you analyse a situation globally.
Yes, well, as I understood his submission is first of all, it's of evidential relevance. Secondly, intention is capable of being an ingredient of unfairness.
Yes.
You would agree with that?
Yes. And in L'Oreal,
Well, L'Oreal appears to be an example. Of
Yes,
that,
the latter, exactly.
because of the way it's expressed.
Exactly, my lady. But intention is not a prerequisite.
No, I think we're all clear about
Right,
that.
that,
I was simply trying to ascertain
Yes.
whether you agree.
I think we're at
submission.
idem,
Thank you.
my lord.
So that's been helpful. Thank you very much for your patience with our
No,
questions.
not
Please
at
continue.
all. Because I am going to slightly change my position in the respondent's notice, which I've already foreshadowed.
Yeah.
And the reason for that, just so you know where I'm going to go, is it in essence addresses a point that my lady raised yesterday about a sequential approach. You need a threshold with respect to similarity of marks, and you then get onto a spectrum, and then you start looking at the other things. But the point is that if you have a link which you can form easily, then the heavy lifting has to be done, the judicial heavy lifting has to be done with respect to the analysis of the unfairness of the advantage, if there is any. But there's another way of looking at it, and that is that it's more difficult to form a link in the first place, and so you don't get to a consideration of the unfairness or otherwise. And that's just a different way of where you put the emphasis on which part of the jurisprudence drives you towards the final conclusion. It's a difference in emphasis more than a fundamental difference in approach. But
doesn't the directive and the statute?
I'm terribly sorry.
Doesn't the directive and the statute which implements it tell you how you approach it?
Well,
because you first of all have to look at whether there is similarity.
Yes, my lord, the statute starts with the threshold requirement of similarity of the mark, sign, goods and services, and then moves to taken without due cause an unfair advantage. The statute does not mention the term link. That comes from the jurisprudence. And so therefore, when you say the statute tells you what to do, the statute has been, shall we say, given a nuance by the jurisprudence, which has introduced this term link.
Well, it's a requirement of causation,
Yes,
which surely is implicit in the statute.
Yes, but everybody's, instead of just saying it's a causal point, has latched upon this term link.
Well, it's just a way of articulating the species of causation which you're interested in.
Yes, and I was actually going to develop that with respect to, in the respondent's notice, what sort of causation do you need to consider?
Okay.
Because at the moment, the way in which it's done is that the causation, the link, arises quite easily once you've got some sort of similarity up and running. You then have to go and explore whether or not that which is being caused is unfair or one of the other heads.
Okay, so is there anything more we get out of L'Oreal?
No.
Thank you.
But staying in the same authorities bundle, please could we go to Whirlpool. This is tab 31. The decision starts at page 1360. And in paragraph 3, which is on page 1364, you can see the graphic representation of the mark shown in outline of the mixed viewed from 3 different angles. So this was the trademark upon which this case was predicated. And then if you go to paragraph 17, which is on page 1368, those are the, that's right, isn't it? No, sorry, that's the actual product that corresponds to the CTM. But then if you turn the page, is that right?
The other way round, isn't it?
This is the other round.
Claimant's a Whirlpool.
Sorry, yes.
And the defendant is
Kenwood.
Kenwood. Well, the K-mix is therefore Kenwood.
Yes. Yes, the K-mix is the Kenwood. Sorry, so that is the 17 is the sign, so to speak, the allegedly infringing wrong. And then it's in paragraph 19. No, that's not, I forget about that.
I thought 19 is the alleged infringement.
Yeah, that's what I thought.
Ah, sorry.
Yes, sorry.
No, you are right. 17, the text, the end of the paragraph
Sorry,
says
yes.
these are the kitchen.
I shouldn't have given way, my lady.
Apologies.
Sorry, let me... 17 is the actual thing that corresponds to the CTM.
Yeah.
And you can see that by the top right-hand front on the face, because it's got that flared base. Whereas the Kenwood product is more upright and has straighter lines. And is given away by the clue that K-mix, the K must stand for Kenwood, I hope. So what happened here?
As a matter of curiosity, why does the print tell us that it's been amended by David Newman? Who is he and how is he amended it?
Sorry, to what are you... Oh, that. I have no idea.
Trust in no material respect.
Well, yeah, I saw that and I just don't know is the answer.
Right.
I don't know to either question.
Which statement of principle here do we look at?
Well, I was going to just put it slightly in context. There was a trial before Mr. Geoffrey Hobbs sitting as a deputy judge, and then the L'Oreal case came down, and so he received written submissions on the L'Oreal case, and you can pick up some of this.
That can't be right because he gave judgment the preceding year, 2008, whereas L'Oreal...
Oh, I'm sorry, it's in the Court of Appeal that that's why, that's how it happened, sorry. Yeah, so the judgment was handed down, it then went up on appeal. They heard the appeal. Before the appellate judgment was handed down, L'Oreal came out and then there was written submissions to the appellate court.
Okay.
And if we go to paragraph 113, which is on page 1400, might actually ask you to read 113 to 115, because that would be quicker. And so what I draw from that is that the use of the term unfair in the phrase unfair advantage has to be given some weight. It's not sufficient that there is some advantage. It has to be an unfair advantage. And then the discussion by the court on unfair advantage starts on page 1404, paragraph 1 through 9. But for present purposes, it's paragraphs 135 through to 136, which is on page 1406.
Yeah, but the conclusion at 138 was there was no advantage at all.
Yes, but in 135 to 136, it illustrates the point that you need to take into account everything. First of all, it seems to me, in this case, is a very long way from the L'Oreal case. Whirlpool did not make any relevant allegation of intention in their pleaded case. Well, in some senses, that's not surprising because of the way, the history of the matter. Kenwood could not have planned its entry into this sector of the market, of which KitchenAid had until then had a monopoly, without being very well aware at all times of the KitchenAid artisan. So that mirrors this case in some senses, that Aldi entered the lemon-flavoured cider market with knowledge of Thatchers. That in itself is not sinister, nor does it amount to anything like what is the alleged infringers did in L'Oreal, because as we've seen, that was predicated upon the imitation point. Kenwood, after all, had its own established goodwill in small domestic appliances. Likewise here, Taurus has its own established goodwill through tens of millions of pounds of sales per year. And carrying on, Kenwood wanted to build upon and rely upon that goodwill, although not in the particular niche of the market to which KitchenAid artisan appealed. It did not need to ride on KitchenAid's coattails so as to save itself from making promotional efforts in relation to its new product. It wished and aimed to use and to develop its own established goodwill and reputation by way of the promotion of its new product. You recall that the evidence of Mr. Watkins, that's Aldi's witness, was that he wanted the new product to be Taurus first and foremost. That echoes these sentiments here. The next sentence in that paragraph is not relevant because it goes to colour.
No, there's a sentence of, as Mr. Purvis submitted, Kenwood would not have wanted to be thought to have produced a Me Too design.
Yes.
That's quite
Sorry.
possibly material.
Yes, I was meant the last paragraph, last sentence of the paragraph, which was the colour. Sorry.
I'm not sure you could make the same submission here, could you?
Well, I can make the submission in the sense that they wanted it to be a product that was in the a la mode lemon flavoured product niche, and they wanted to carry on promoting their Taurus products. 136, I do not consider that Kenwood's design involves anything like the transfer of the image of the KitchenAid mark or of the characteristics which it projects, the goods identified by Kenwood's sign. Of course, as a newcomer in the specialist market of which KitchenAid had a monopoly, and being necessarily in the basic C shape of a stand mixer, the K-mix would remind relevant average consumers who are design aware of the KitchenAid artisan. That, however, is very different phenomenon in very different commercial circumstances from the situation considered in L'Oreal. I find the court's judgment instructive, but it does not seem to me to lead to the conclusion in favour of Whirlpool for which Mr. Mellor contends. On the contrary, having rejected his radical submission that the word unfair could just as well have been left out of the article, it seems to me that decision points away from rather than towards liability under the article on the facts of the present case. It is not sufficient to show, even if Whirlpool could, that Kenwood had obtained an advantage. Now, in this case, one of the findings of the fact by the judge is that there was no advantage. There must be an added factor of some kind for which that advantage to be categorised as unfair. Now, in the L'Oreal case, there was an advantage, and the added factor was the intention. That's moved it from an advantage to an unfair advantage. It may be that in the case in which advantage can be proved, the unfairness of that advantage can be demonstrated by something other than intention. Well, I'm going to come to some cases where that might be so, which is what was shown in L'Oreal, because the intention was shown in L'Oreal. But in the Whirlpool case, no additional factor can be identified in this case other than intention. So what I get from that is that you might be able to get unfair advantage up and running with some other way apart from intention. But just because you're moving into a market that was previously a monopoly, or at least dominated by one player, in of itself is not nefarious. It's not blameworthy. And if we go to the Jack's Wills case, this is actually a case where, for various reasons, intention wasn't a factor. And so there were other reasons why there was held to be an infringement under 10.3. Now, Lord Justice Arnold mentioned yesterday that, of course, this is a first instance case. Yes, it's in the second authorities bundle behind tab 13. And as we've been explaining, every case turns on its facts. So, second authorities bundle, tab 13. This time I hope I get it right. The logos are detailed in paragraphs 5, 6 and 7, which all fall on page 449. You turn the page, and under paragraph 8, you will see the allegedly infringing sign, which is that pigeon with a top hat and a bow tie. And then in paragraph 11, it actually details the trademarks and how they correspond to the logos that were shown previously. Now, the long and short of this was for clothing, and I was going to jump, if I may, to page 469, paragraph 95. This is the conclusion with respect to the comparison between the marks and the pigeon logo. Accordingly, I conclude that there is a reasonable degree of visual similarity and a high degree of conceptual similarity. So in that case, there's a much higher degree of similarity with respect to the marks and sign than in this case. And then if you go to the next page, 470, paragraph 103, this is the conclusion under section 10.2, so whether or not there exists a likelihood of confusion. And the conclusion is that there does exist a likelihood of confusion. Now then, starting at paragraph 104, we start the analysis of under 10.3.
On the assumption that there's no likelihood.
Yes, that's what I was just going to say. Is that starting point here was that, contrary to the finding made in the previous paragraph, assuming that there was no existence of the likelihood of confusion, you then go on and consider whether or not 10.3, in essence, freestandingly, is still made out. And in 109, at the bottom of the page, through to 110, if I could ask you to read those two paragraphs to yourself. So you can see that this analysis is predicated upon the assumption that there does not exist a likelihood of confusion. And also, because there was this pleading point, it was not open to the claimant to allege that there was an intention of free riding on the reputation. However, 10.3 was still made out, and we would say one of the reasons for that is that it was intended, the pigeon logo, to have brand significance. And in this particular market, so again you have to look on a case-by-case basis, in this particular market, the use of those fancy embroidered logos was something that was intended to convey brand significance. It wasn't decorative in any shape or form. It wasn't non-distinctive. And so therefore, in that case, it's an example of another factor which gives rise to a finding of infringement, where that other factor is not intention, and that other factor in this case was the intention that the allegedly infringing sign had brand significance, which arose in the context of that case. And in contrast, in this case, that which has been taken or copied using those prejudicial terms is something that doesn't have brand significance, because the only commonality between the sign and the trademark are the things that have a descriptive meaning or a non-distinctive. So the descriptive bits are the lemons and the words, and the non-distinctive are the overall colour palette. So the present case is distinguishable from the Jack's Wheels case. Then I was going to take you to Claridge's, because in some senses this shows another way in which you can give rise to infringement. Claridge's case is in the first authorities bundle behind tab 6. And at page 97, paragraph 30, what is also clear is that the advantage has to be unfair. The mere fact of gaining an economic or commercial advantage is not enough. So that just hammers home that point. And then if you go to paragraph 54, which is on page 101, This is under the heading transfer of image. So the point here is that one is looking at claridges and claridges in essence. And I would say what distinguishes this case, and the reason why it's perfectly reasonable to find a 10.3 infringement, is because the very thing that was taken, namely the word claridges, has an aura around it that conveys a whole load of messages with respect to, as the judge said, luxury, glamour, elegance and exclusivity. And so that was the mechanism whereby those things were conveyed. So by using the same word, in this case, you managed to transfer the image from the trademark to, in this case, the infringing sign. And so that's why, even though intention can be important, it's not a prerequisite. And there are cases here, Jack's wills, for example, where certain intention elements weren't there, but there are other factors. And in this case, Claridge's case, you can see why there is a transfer of image. But again, that's in contradistinction to this case, because the things that are common between the sign and the mark don't convey anything other than descriptiveness, the lemonness of the product.
How do you reconcile that submission with the judge's finding that the sign would call the trademark to mind?
Because what I'm going to say on that is the calling to mind is the link. And the way in which she has analysed it is you can form a link very readily, even with respect to things that do not have any trademark significance. So, if, for example, I see a particular shade of green, no, that example doesn't work, sorry. Yes, if I see the word cider, that could call to mind Strongbow, because Strongbow is the market leader. And you can say that the use of the term cider is the causal link of calling to mind. But the term cider doesn't have any trademark significance at all. It only calls to mind Strongbow because Strongbow is the market leader. And if you're going, no,
Sorry, I can't. That's the factual premise of this submission is one that I find impossible to accept.
well, my lord,
That's not calling to mind.
yes, it
Strong.
is. No, see, this is exactly the point, my lord. The point is when you're using the phrase calling to mind, it could just be that it calls to mind for some very weak reason, like the word cider calls to mind.
Yeah, that wasn't the judge's finding. She didn't find, unsurprisingly, that Taurus called Thatchers to mind. It's plainly different brand names. She didn't find that there was a calling to mind because of cider. She didn't find that there was a calling to mind even because it was cloudy lemon cider. What she found was that there was a calling to mind because of what you call the decorative elements.
Yes. But, sorry, my lord, I was starting at one point and moving forward, in the sense that the calling to mind phrase could literally be as simple as you say the word cider and somebody calls to mind Strongbow.
Well, that may be, even if that's right in theory, we need to focus on what the judge.
Yes, but to explain where I'm going to go, that's why I started off there. Then you move along the spectrum. At the other end of the spectrum would be claridges, used by the defendant. That calls to mind the hotel, indisputably. But
Well, you say indisputably, but it was disputed in that case because, of course, the defendant's product was candles, and their case was nobody would think that candles had anything to do with the hotel. And the judge said, come off it.
yeah, that's why I said indisputably. But what I'm trying to set up here, my lord, is a spectrum. You don't like my cider example, but I still put it forward in the face of judicial opposition because it does start the spectrum. The other end, you have something which clearly calls to mind, and then you have a whole spectrum of things in between, and we fall on that spectrum. But the things that caused the judge to say and to find that there was a calling to mind was what I say are the descriptive, non-distinctive elements. Now, if you're going to set the hurdle, so to speak, quite low, then that's fine. In the responder's notice, I say that actually there should be a much higher threshold before you say something is called to mind, and it should only be crossed when the things that cause the calling to mind have trademark significance. Now, in this case, the thing that caused the calling to mind did not have trademark significance. And I say that's important because if you're not using that causative link to do much heavy lifting to see whether things fall on the right or the wrong side, you have to make a closer examination of whether or not there's an unfairness to any advantage that is taken. Whereas if you say that the causation has to be set at a far greater level, in the sense you can only surmount the causation point if it is satisfied by trademark matters, trademark elements, then you can do less work on the unfairness. It will be easier to prove unfairness. So it's where you put the emphasis on so as to reach the overall conclusion. And the judge said there was a link, fine, but the link, the causal event, was predicated upon non-trademark elements. I say if that's the case, then you have to examine far more closely what is the alleged wrong, in this case unfair advantage. And that's why I'm emphasising so much the unfairness, because there might be some advantage, but you have to examine far more closely whether that advantage is unfair. That's the clear law. You have to give weight to the unfairness element.
Well, in a sense, you're saying no more than this is a fact-specific global assessment.
Yes. With which you should not interfere, my lady.
Yes.
With all
I get your submission.
But I'm sorry, I don't mean to be cheeky, but the point being
No, I understand what you're saying.
There's different ways in which you know, places you can put the emphasis and put the heavy lift in.
Well, I understand the submission, and of course, this is a key issue on the appeal, is whether there's any justification for this court intervening.
Yes.
But since the general heading you're under is that of transfer of image, we haven't yet heard your answer to Mr. Howe's submission that the court is justified in intervening for the very simple reason that the judge nowhere addressed the case on transfer of image. It's simply not dealt with in the judgment.
Well, you see, that phraseology was not used in the judgment, correct. But I started this whole section off by saying, where was the phraseology used in the particulars of claim? And that was the way in which the case, so to speak, was run before the learned judge.
Well, that's not correct, as we've seen from the skeleton argument. The way it was advanced in argument was crystal clear. It was under the heading of unfair advantage, and there was a very clear allegation of transfer of image put.
Yes, my lord, but that was under the change in economic behaviour, so to speak, subsection of the unfair advantage.
So what? It's still part of the unfair advantage case, and it's still
Yes.
not dealt with.
But it did not form front and centre of the submissions made before the judge. Yes, it turns up twice, my lord. Once in the pleadings where I've shown you, and once in the skeleton argument. That's the totality of it.
And it was also repeated in oral submissions.
Yes, but with respect to the pleadings, that's it. It was not front and centre of the unfair advantage argument in the way in which my lord is characterising it before me now. And so therefore it's not, if it had been front and centre.
So this amounts to a submission that if I advance a primary case and an alternative case, then the court can simply ignore the alternative case. Because it's not the primary case and it's therefore
No,
not
my
front
lord,
and centre.
I'm not making that submission at all. What I'm
Well,
saying...
is
sorry.
the court on your submission entitled to ignore an argument because it's not, to use your words, front and centre?
No, I'm trying to make a different point. The court is supposed to consider, in essence, all the arguments that are put before it, even though, of course, it's entirely appropriate, and the Judicial Court of Appeal Authority on this, that the judgment does not need to reflect each and every argument that has been advanced. And those arguments that are addressed can be addressed more or less thoroughly, depending upon the appropriateness of to do so in the judgment. But the way So, if we go to the judgment in the core bundle behind tab 7, the judge starts off on page 141, paragraph 127, discussing unfair advantage. Those behind me have said it would be useful to go back to the beginning of issue 5, which is on page 140. And this is where she goes through some of the cases. So 123 is the little case. 124, unfair advantage. She refers to the L'Oreal case. 125, in terms of an intention to take advantage, there's the Jack's Wills case. And in the L'Oreal case, I've just been asked to point out to you, there's an express mention of paragraph 41, which is the transfer of image paragraph. And then her analysis on unfair advantage starts at paragraph 127. (129) stresses the point from Mr. Watkins' evidence that Aldi added lemons, in part because Thatchers had, but mainly because lemons and lemon leaves, and particularly whole lemons in his view, were very effective to communicate the fact to consumers that this was a lemon cider product. And then 131 on the next page, 143, sorry. And it's, I mean, all of that is relevant, but the last sentence is particularly so. On balance, I am satisfied that Aldi did not develop the Aldi product, being the sign, with an intention to take advantage of the goodwill and reputation. So all of that is a summary of the things that have gone before, which she's expressly mentioned, including the transfer of image point in the L'Oreal case. And that's her overall view. Now, she might have elaborated her reasons more fully, but she set out the relevant law.
So your submission is that she's taken transfer of image into account even though she doesn't mention it?
Well, she's expressly referred to the right paragraph where the phrase is used in L'Oreal.
Without mentioning transfer of image?
Yes, but in that context, my lord, that was actually paragraph 124. She refers to L'Oreal, and then she only refers to paragraph 41. She doesn't just say L'Oreal full stop, so to speak. So it's reasonable.
So you say she had it in mind?
Well, paragraph 41, though, makes a more general point about taking unfair advantage, and then it goes on to say it covers in particular cases where, by reason of a transfer of image.
My lord, yes.
So you can refer to paragraph 41 without necessarily dealing with the particular case of transfer of image.
My lord, I accept that because, I mean, I have to accept it because she hasn't mentioned the term transfer of image expressly. But having referred to paragraph 41, it's a reasonable presumption that she's read it. But those behind me have done a word search of the entire transcript of that which occurred before her. And they say that the phrase transfer of image was mentioned only once at trial by Thatchers. So that brings the sum, the grand total, to 3. Once in the pleadings, once in the skeleton, once in the transcript. So you're criticising the judge for not having used the phrase. But in my submission, that's just unfair. What she's done is considered the statutory wording. And in 131, which I've just taken you to in the last sentence, I rely upon the fact that she found, having listened to all the evidence, and remember, Mr. Watkins was cross-examined at length on this, quite robustly. I'm satisfied that Audi did not develop the Audi product.
Well, you say transfer of image was mentioned only once, but the submission that was made, and it was made in opening the case, was this is classic unfair advantage by a transfer of image, a classic case like L'Oreal and Bureau, and we will respectfully say it falls squarely within the guidance of the Court of Justice in L'Oreal and Bureau.
Right.
So,
but she's referred to L'Oreal, and she's referred to the relevant paragraph.
all right, but the point you were making, I thought, was you say this point wasn't front and centre. Apparently because counsel thought it was sufficient to make the submission once and didn't repeat it 5 times.
Well, my lord, it's a phrase that really did not stick in the mind of the judge. But what did stick in the mind of the judge is all the relevance jurisprudence. And in my submission, she cannot be criticised for failing to use a 3-word phrase that has been used thrice in the entirety of the papers before her.
Okay.
I have some difficulty with that when she's referred to the leading authority and to the paragraph which considers in particular the transfer of image. fact that the parties haven't continually used that phrase before her doesn't mean that she isn't aware that that is a relevant question to ask.
Well, the relevant question to ask is whether or not there's been a taking of an unfair advantage, and the transfer of image is, in essence, only one potential way in which that can be manifested.
But that point was taken in opening.
Taken in opening.
So, and she's aware of the law in relation to it. So, I'm not sure how the fact that it wasn't used lots and lots of time in the trial means that she can ignore the point.
No, I'm not suggesting she ignored the point. Quite the contrary. What I'm saying is the reason she didn't use the phrase is because the phrase was not repeatedly put before her. What she has dealt with, fully I say, is the necessary legal concept of whether there's a taking of an unfair advantage. So she's been looking at whether or not there's a sufficient similarity in the sign and the mark, and whether there is some, in essence, link, and whether that link gives rise to the necessary wrong.
But doesn't she have to consider, because it was alleged and because it's recognised as being a particular example of taking advantage, whether there was a transfer of image? And do you say she did that?
I say she must have done that implicitly because she analysed and took into consideration all the matters before her.
You say she did so implicitly. Do you accept that if she didn't do so implicitly, then that was an error?
The reason I'm hesitating, my lord, is because it depends how she understood the phrase. Because if she just thought it was a phrase that was a useful label that carried no particular jurisprudential weight.
But it's not a useful label. It's quite a specific concept, as one can see from Jack Wills.
Yes, and just one second. She referred to Jack Wills,
but not the relevant passage.
Not the different paragraphs, admittedly, 75 to 80. So, in answer to my Lord Justice Phillips' direct question, it could still be that it would not be an error if she still performed the correct analysis, which I say she did. If she didn't, within her internal thinking and her internal rationalisation of the case, turn her mind expressly to the phrase transfer of image, but still considered all the relevant points, then it would not be an error. I say that she did clearly turn her mind to all the relevant points. And you can see that, as I was going to say, in the last sentence of 131, paragraph 131 on page 143. Satisfied that Aldi did not develop the Aldi product being signed with an intention to take advantage. So it's not just take unfair advantage, not just to take no advantage.
So why, on your submission, did they reference it?
Well, because, my lord, in the same sort of way that it's perfectly proper when you're taking a benchmarking approach to the product of a new product, you look at the market leader.
Yes, but the judge found in terms that your clients didn't just look at the product and use that as a reference. They looked at the packaging and used that as a reference.
Yes, but that's...
So,
sorry.
What on your submission on the judge's findings was the purpose?
Because one is perfectly at liberty to look at the product leader in any particular niche market. That's the benchmarking process. And it's perfectly proper to look at not only, for example, the contents and the quality of the contents, but also the way in which that product presents itself to the market. And in particular...
That's a submission that whatever the purpose was, it was legitimate. You still haven't identified the purpose.
The purpose is, in this case, to see how, for example, Thatchers presented its product to the market, and, for example, how it conveyed the lemonness. Mr. Watkins' evidence was that they thought, that's Aldi thought, that Thatchers conveyed the lemonness message well. And the whole purpose of this, Aldi's product, Taurus's cloudy lemon product, was to break into the lemon niche market, which was a la mode at the time. Therefore, it's perfectly proper to see how somebody, the market leader, has conveyed its lemonness. And there's nothing unusual that they found. The lemonness was conveyed by the use of
so
lemon.
where did the judge find that Aldi's purpose in using Thatchers as the sole reference point was in order to convey the lemonness of the product?
Well, she accepted Mr. Watkins' evidence.
Where did the judge make that finding?
Actually, it's in paragraph 131, I think. Oh, and 129 as well, sorry.
So that is reciting the evidence.
Which she
What
accepts.
is-
She appears at 130 then to consider that because Aldi intended to effectively keep a safe distance away, that was sort of determinative.
Well, it was certainly a factor that she took into account.
Indeed.
But she was right to do so, we would say. My lady, that actually brings out the point that the paragraph 80 of Planet Art that's quoted in 130 of the judgment, my lady friend pointed out the fact that that's relating to the passing off part of Planet
Indeed.
Art. But the point is that if you read paragraph 80, yes, it might be in the context of the passing off part of the Planet Art case, but Mr. Alexander's comments are really going to the way in which you need to handle the evidence of a witness. And that's the bit she's picking up upon. And if you look at Planet Art, well, the point is that that's equally applicable to however you look at the evidence on 10.2 or 10.3.
Yeah, I think we're diverting you onto intention, so
Yeah.
perhaps we should come back to that when we get to intention. Is there anything more you want to say on transfer of image?
Well, it's literally just two very short points. The first point is that the mere use of something might be because it looks nice, so to speak. So there's many reasons why there might be something that's attractive that you wish to use. And if there's an advantage that is gained because something is attractive, I would characterize that as a mere commercial advantage, which is not enough to constitute an unfair advantage. And in 134, she details the things that are common between the sign and the mark. And it's the descriptive words, the limited colour palette, which is ubiquitous, and the commonplaceness of the lemons and what have you. And this is where she concludes, I'm not satisfied of an intention to exploit the reputation and goodwill of the trademark, or that the use of the sign has objectively had that effect. So she's reached, as a matter of fact, there's no advantage. But even if she had reached the conclusion that there was some advantage, it wasn't an unfair advantage. And she says, in contrast to L'Oreal, there's no intention. And in contrast to Jack's Wills, the things that were common, that were taken, had no brand significance. So there's no other factor here that can undermine her conclusions. I was then going to, because we're moving very slightly towards that, the pure intention point, if I may.
Yep.
You can see from the transcript, this is in the supplementary bundle, tab 25, and it starts at page 107, but on transcript pages it's 161 to 164, that Mr. Watkins was robustly cross-examined on the intention point and basically held his ground. And that's why my submission is perfectly reasonable for the judge to have reached the conclusions that she did. Probably now appropriate to go to Planet Art, which you can find in the third authorities bundle behind tab 22. And the discussion in Planet Art starts on page 876 at paragraph 37, runs through to paragraph 39 on the next page.
Now, just before we get into this in any detail, can you just sort of orient me as to where we are here? Because there's two separate questions here which one needs to disentangle. The first question is, what is the correct approach as a matter of law? The second one is whether she misdirected herself. Now, the reason why I disentangle those two questions is that, as of course you know, I considered the first question in some detail in Glaxo Wellcome.
Yes, I was going to go to Glaxo next. But
So, which of course the judge doesn't reference.
no.
I don't know whether she was taken to it. Maybe she wasn't.
I've
and
been
so-
told behind me that she was, but yes,
So Glaxo Wellcome was cited.
my lord, yes.
Right. Okay. All right.
I don't
well,
know. Yeah.
Okay. Well, that's a little strange, but there we go. Thank you.
Well, to answer your first question, I think that you posed is intention is primarily evidential, but it could, in the sense of 10.3, as my learned friend has submitted to you, potentially in certain circumstances constitute an additional element.
Yeah.
Substantive.
Well, I understand
Sorry.
that, and you've helpfully made that clear already. But
Sorry.
but coming back to the question of what we're doing when we're looking at Planet Art,
Yes.
what we're doing is looking to see if the judge misdirected himself.
Right. Second of your two questions, then.
Because, as I understand it, you're going to take the law from Glaxo Wellcome.
Oh yes, Planet Art and Glaxo. Yes.
Right. Okay.
So I'm not disagreeing with any of the law. And the way in which I started off was taking you to paragraph 37 of Planet Art. But the most important thing here is that this part of this case is under the 10.3 consideration. You can see that at the beginning of just before 37, the relevance of the defendant's intention in the case of unfair advantage. And then the various quotes that are given, in particular from Specsavers. In paragraph 39, the judge in Planet Art says, although that was said primarily in a case under 10.2, it is equally applicable to a case under 10.3. It's one thing to live dangerously in the sense of pushing the boundaries of legitimate creep up on an incumbent. It is another to intend to deceive.
Do you defend that as a correct statement of the law, given that intent to deceive is not part of the 10.3 case?
In the sense that sorry, let me backtrack on something. If I've understood your question correctly, my lord, what you're saying is that you can't marry it across completely because the wrong that is under 10.2 or 10.3 doesn't necessarily contain a deception element. Is that question?
Well, Mr. Howe's case is that the judge got confused between intention to deceive, which is relevant to likelihood of confusion, evidentially, and intention to exploit someone else's reputation or goodwill, which is a different intention, and its common ground is relevant, at least evidentially and possibly more, in the section 10.3 context. And Mr. Howe seeks to support that submission by arguing that the judge cites the wrong bits of Planet Art in the relevant places. So she cites the 10.3 bit in the
Yes.
likelihood confusion analysis and vice versa. But when one looks at Planet Art, one might say that the judge in our case can be forgiven because the deputy judge in that case sowed the seeds of the confusion in this very paragraph.
That was where I was going. So
Which is hence my question about what actually is the law and the relevance of Glaxo Wellcome.
Sorry, I didn't quite see where you were going, my lord. What I'm trying to say is Glaxo Wellcome, fine, we accept all that. But the point here is that the judge was looking at a number of different cases, Glaxo, Planet Art, a number of different parts in particular of Planet Art, which touched upon different bits, passing off and 10.3. And what she's trying to do is draw from all of those an understanding that if there's some sort of intention to do that something's wrong, then that is potentially an evidential matter that you can feed into the assessment and might make the whole thing bad and actionable. Now, the particular details here with respect to 39, where it's arguable that the wrong terminology has been used by, in this case, the Deputy Judge, Mr. Alexander, it ought to be said, but I'm asking you to take, I suppose, judicial notice of this, that particular Deputy Judge is fairly familiar with the law of passing off and trademarks.
I have no difficulty with that.
No, but the reason I'm saying that is
doesn't mean he's infallible. Nobody's infallible, including us.
yes, exactly.
That's why we have the Supreme Court, who are infallible.
Ex cathedra, my lord. We'll move on from the theological arguments to later. What I was going to say was that some deputy judges, when hearing intellectual property matters, are less familiar with intellectual property matters and the nuances between passing off 10.2, 10.3. My submission is that this particular Deputy High Court judge is quite familiar with those nuances, and yet even he has made, on close analysis, an error, or arguably an error. But it doesn't disturb the overall thrust of what he, in that case, and our judge in our case, was trying to do, which was trying to find whether there was any nefarious intent. And the intent, in particular, needs to be judged upon the demeanour of the witness. All those, not just answers, the way in which the answer is given. And in paragraph 80 of Planet Art, that paragraph is mainly, even though it's in the context of the passing off analysis, is mainly an analysis about the demeanour of witnesses and how you're supposed to understand.
Sorry, did you say paragraph 80?
80, yes, my lady.
Oh.
In Planet Art, page 887, if you're on the...
Apologies.
Can you see it's Little Roman 5, got the heading above 79, relevance of defendant retention,
yes.
passing off case.
Yes.
And then it says in 80, however, just as within trademark infringement. But if you read 80, the way in which the deputy judge is expounding matters is the way in which you evaluate the thrust of a witness's evidence. And that's applicable, in my submissions, to passing off 10.2, 10.3. You need to be wary of why a witness might be hesitant or cautious.
What do you say about the familiar observation that the truth of the matter is quite often better revealed by contemporary documents?
Well, we can't resile from that. There's no allegation here that any of the documents were forged or anything like that, so therefore you read them. So therefore you read them, you know, for what they're worth.
Yep.
But those contemporary documents should be interpreted in the light of the oral evidence, of which there was an extensive amount. The witness showed themselves, and presumably their true intention, or at least that is what the judge was there to perceive, and she reached a conclusion upon how she perceived the witnesses.
I think judges are regularly warned not to pay much attention to demeanour these days. So,
My lady, yes. I mean, but it all goes into the mix.
That's your point.
Yeah, it all goes into the mix of the fact that having seen the witness being cross-examined and the answers that the witness gave, she formed a view, and she formed a clear view. It wasn't that she thought, it's a bit dodgy on this, a bit dodgy on that, but overall I accept the evidence.
Well, as I indicated earlier, my slight concern at the moment, or some concern, is that she focused on Mr. Watkins, what she assessed as Mr. Watkins' evidence of having effectively endeavoured to keep a safe distance away. And that, my reading of the judgment at the moment is that she regarded that as
Important.
really important.
Yes.
And I have to say I find that quite difficult. Seems to me that it's the court rather than witnesses to determine
No, I see what you're
where
saying.
the line is
Yes.
to be drawn.
No, I understand that. Well, I think I understand, my lady. But the point being is that the case law does indicate that the intention to try and avoid infringement is a factor that you take into consideration.
Well, we'll come back to the moment, but can I put my lady's question in a slightly different way, which is, it begs the question, what is meant by safe distance? Because safe distance viewed through the prism of intention to deceive is not the same thing as safe distance viewed through the prism of intention to benefit from reputation and goodwill. And you may intend to keep a safe distance in the sense that you don't intend to deceive consumers, but still intend to take the benefit of the reputation and goodwill.
My lord, yes, I see. There's the neat middle ground, so to speak. So the way in which I would answer that is that, yes, the close textual analysis of the various passages that she has quoted in the various places she has quoted them might prima facie suggest that she's applying the wrong test in each place. But in my submission, she has taken all of those points on board, and when she's applying her mind to the relevant test in each place in the judgment, she has formed a view of the defendant's, evidence, Mr. Watkins' evidence, in the round that, as in 131, no intention to take advantage of the goodwill and reputation. So, close textual analysis with respect to the case citations in the various paragraphs might be out of kilter, but the conclusion that she has drawn, taking everything into the round, is still that there was no intention to take an advantage of the reputation. Now, it might not be perfectly expressed, and my lord has clearly pointed out the glitch in paragraph 39 in Planet Art. Now, we're not here to question whether Planet Art is good or bad, but I can rely upon it as an example of the fact that even experienced judges in this area don't always express things perfectly. And in some senses, the crime of which this judge is being accused is a lesser crime. That's not to say that, of course, in both cases they might still be fault-worthy, but I can only go that far, my lord.
Yep. Okay, thank you. You were going to take us briefly to Glaxo Wellcome, I think.
My lord, if I may, you can close bundle 3 if you still have it. Glaxo may be found in Authorities Bundle 1, tab 10. The relevant bits are paragraphs 182 to 189, which commence on page 360.
My recollection is that this is all about likelihood of confusion. There's nothing about 10.3, is that right? Because it was a passing off case.
Yes.
It's the trademark had been invalidated before the trial.
Thank you.
Therefore, it's just passing off.
Yeah.
And it's paragraph 188 on page 362. Which is the point about crossing the line. And so, yes, my lord, there is a difference between intention to deceive, intention to take unfair advantage, and various other intentions. But the judge, in her summary, the last part of paragraph 131 of her judgment, is just a comprehensive refusal to hold that there was any such nefarious intention, full stop. So therefore, that's a summing up sentence that says whichever intention you're looking at, it wasn't there. Now, she didn't go through each and every step of each and every type of intention. But in context, if read fairly in my submission, you can see that she has considered everything. And it might not be perfectly expressed, or not expressed in the way in which others would express it. But that's not a reason for overturning her conclusion. That's really how I was going to end on intention.
Thank you.
I was going to go on to the issue with respect to lines. This is ground 7.
Yep.
This, I hope, will be quite quick. Sorry, I should have said, are there any other questions from anybody about intention? No, we've done that today. So, moving on to lines. The very first point that you need to note about these lines, which in my submission have become far more prominent than they really ought to be, is that they turn up once in the evidence. They turn up in the reply evidence of Mr. Milton at paragraph 8. So it's his second witness statement, which may be found in the supplementary bundle behind tab 24 on page 79. And it's the last sentence of paragraph 8. For example, Aldi's product includes horizontal lines similar to those that appear on Cloudy Lemon. Tab 24, page 79, paragraph 8, last line. That's the totality of the evidence. There are no pleading on the point. There's no pleading that the lines were an indicium of copying.
Well, there wouldn't be, because it's not a copyright case.
No, but it's now being relied upon as an indicium of copying.
Well, the pleading is highly similar, or words to that effect. Words to that effect, isn't it?
But it doesn't mention the lines at all. So this is the first time.
Okay.
And the reason, sorry, you're going to carry on.
No, I was just
sorry.
speculating as to why it would need to go through all the details of the similarities.
I understand, yes, I understand your point, I believe, because the lines are so faint that the only time, the first time Mr. Watkins, that's Aldi's witness, noticed any point about lines is when it was mentioned in this sentence. Just a second. If you are still in the supplementary bundle and you go to the next tab,
Don't have tabs.
I'm terribly sorry, page 103. No, that can't be right. It's page 102. And it's on of the transcript, the mini transcript, page 142. Line 16, answer. I was not aware of the lines until Mr. Milton's second witness statement. And he carries on, they're so faint, they're not noticed. Sorry, my
So
lord.
yes, I've got it. Yes, go on.
And then I was going to deal with the next point of page 143. This, in essence, answers a point that my Lord Justice Arnold made yesterday about why did nobody mention them? Well, and why was there no explanation as to their presence? Because it just wasn't in essence, play until the cross-examination. And so when Mr. Watkins is being cross-examined about this, and you see this on page 143, and question starting at line 8 and the answer at line 10, they are lines on a can, absolutely. As to how they ended up there, I'm not sure. So he doesn't know.
Well, the only explanation is it was part of what the design agency did, and the only explanation for that is they got it from Thatchers.
Well, can I come to your point in just one moment, my lord?
Well, is there any alternative explanation?
Well, I was just going to carry on and make good the fact, if you turn the next page to 144, that Mr. Watkins didn't know why they were included. You see that at line 13. But just before that, in the first part of that mini transcript, page 144, he does accept the lines give rise to a different feel.
Yes.
Now, my Lord Justice Arnold has the cans, but if you actually look at the lines in question, there's quite a lot of difference between what appears on the Thatchers product and what appears on the Taurus product. And there's at least, I would say, 3 points. Is that on the Thatchers product, certainly at the bottom, the lines seem to be representing clouds. They're not just plain lines.
Really?
They're in clover leaves.
It's not apparent to me.
Well, but you can see that
And
there's...
why would they be representing clouds? That makes no sense.
Well, I'll come to this in a moment. There's also other differences. There's more lines on the Thatchers product, and they're also more uniform in their width. Now, coupled with the fact that it clearly hasn't been copied across minutely, and coupled with the fact that this only really turned up in cross-examination, which would explain why there was no evidence on it from Aldi.
Well, you say it only turned up in cross-examination, but as you very fairly pointed out to us, it was mentioned in Mr. Milton's second witness statement, if not before, and so inquiry could have been made at that point.
Yes, my lord, it is mentioned, but it's mentioned in passing.
Well, it's mentioned in a very specific context, isn't it? I mean, it's not just said, there's lines, and this is of no significance. On the contrary, the point that's made by Mr. Milton is, there's lines, and this is significant.
In reply evidence, in IPEC, which is the end of the evidence.
Except it wasn't, because there was cross-examination.
At which point, you can't go and ask the designers, or the graphic designers, why there are lines in the Taurus product.
Why not?
Sorry, during the trial. Sorry, I've lost the thread of your question.
But between the date of service of the witness statement and the trial.
Because the way in which IPEC trials normally works is that's the end of the matter. There's no particular indication that there's going to be a big song and dance about one line in a replied piece of evidence. So what you do not know, given that there are differences between the lines in the two products, I would say manifest differences when you look at them in detail, is whether or not there's an alternative, entirely innocent explanation, which is one that accords with the acceptance by Mr. Watkins that the lines give rise to a different feel. It might well be that it's just a common device amongst graphic artists, and this is a submission, not evidence, that those sorts of lines, that sort of shading, is done so as to add some sort of depth, so as to remove the flatness of what otherwise would be a plain.
But would you accept that they're not present on the other products in the Taurus range that went before?
I actually can't answer that because I don't know.
Well,
But
black.
Well, it looks black from the photographs that we've got, but from the photographs that we've got, you can't see these lines. That's the whole point about these lines. Nobody noticed them. Mr. Watkins, who is the man in the field, so to speak, didn't notice them. And he says it was only on the third reading of the second witness statement that he noticed it. So that's all I have to say on lines.
All right, thank you.
Oh, I see. Where's that? My learning junior has found a reproduction that might make good one of my submissions. It's in the supplementary bundle, page 143. And there you can see the lines more clearly. And
Well, it's a design option. It's not.
no, except
It's
that.
and there the lines are in grey, but they're not in grey at the end of the day.
No, but the point being is that there they look more like clouds. And of course you are talking about a cloudy lemon cider. But if you look at that design option too, and then you look at the actual, and then if you go to the next page, design option 3, you can see first.
So I see. So the point you're making is essentially just a change of colour, and then if you look at the lemon, you can see the outlines a bit more clearly.
Yes. So
I still think you were more closer when you described them as a clover leaf shape. But there we go. Okay.
I thought it was clover leaf when I first looked at it, but then I decided to use the term cloud because of cloudy.
Yeah.
That's the depth of my submissions on that.
All right. Thank you.
But what I was trying to say is that that has some feature to it, whereas if you look at the lines on the Taurus product, from what I can see, they're just straight lines. There's no sort of moulding into either a clover leaf or a cloud. That was the point of that submission.
Thank you.
I've got nothing else to say on lines, and I don't think there are any questions from the bench. Right. With the court's permission, might my learned junior address you upon the other matters with respect to the appellant's
Sure.
appeal? You don't mind if she sits while she's addressing you?
Indeed not.
Thank you. Sorry, I'm going to try and move some of my bundles so that you can see her.
Yes.
My lords and my lady, hopefully you can hear me okay from further back in the lines. I'm grateful I don't have the outside noise to compete with today. I propose to address you on ground 8, which is tarnishment, and then grounds 10 and 11, which go to issues relating to the sign. On the tarnishment ground, I have 3 fairly short points on this. First is that all that was pleaded in relation to tarnishment was that there was a difference of taste and composition. All of these issues around whether it's misleading or not is not a pleaded matter, and therefore we say not something that really should come into the issue at all. The second point is that tarnishment based on this mere allegedly, and indeed admittedly benign difference is a concept of tarnishment unknown to law and wholly without merit. The third point is that even if there was, it was right to take into account the packaging issue, that really would have no impact on the case on tarnishment at all. So turning to the first point, could I please take you to the particulars of claim to see how this was pleaded? It's in the core bundle, tab 9, and it's paragraph, so core bundle page 166. And this is paragraph 20, subsection D. We've looked at the first half already in relation to transfer of image. Can I just ask you to read from on the 5th line down where it starts with further to the end of the paragraph. That is the whole totality of the pleading in relation to tarnishment. Effectively, it's an allegation that Aldi have done something wrong by not producing an identical formula to the cider. There's certainly no allegation that it's worse, and there's no issue around anything to do with packaging. Which takes me to the second point, that there is no basis for this argument at all. You've not been taken to any authority that difference alone can be sufficient to found a case of tarnishment, thus because there isn't any. There would need to be something really damaging for there to be this rub-off effect, which I referred to. For example, if it tasted terribly, or if it looked like...
I don't understand. Can you assist me? I'm not sure I understand the point you're making. So, why is a difference in taste not capable of amounting to tarnishment? I mean, let's take the variant of the chlorine case. So in that case, the product, defendant's product, was actually detergent. But suppose it had actually been gin, but it tasted of detergent. The result would have been the same, wouldn't it?
Yes, so I'd accept that, because there's clearly a negative issue here. There's no...
But you were submitting that a difference in taste was incapable as a matter of law of constituting tarnishment. And I'm trying to understand the basis for the submission.
Sorry if I wasn't clear on that. My submission is that a sort of benign difference in taste, where it's accepted that some people might think, because taste is obviously subjective, and that's something that the appellants have made clear. They're not suggesting that everybody will think that the Aldi product tastes worse, and indeed some might think it tastes better. It's a matter of personal preference, which is quite different to whether a gin tastes like detergent, or indeed whether it is actually detergent. There would need to be something inherently negative in my submission to really found a case on tarnishment in this way. Otherwise, there's simply no damage to the repute of the mark if some people actually think it tastes rather nice.
So let me see if I've understood correctly, because it's obviously my fault for not having understood the submission you were making originally. Do I understand, therefore, that what you're submitting is it has to be measurable? It has to be a measurable difference? Is that the submission?
The submission is that it has to be negative. So effectively the pleaded case is there's a damage to reputation because it's not precisely identical. Therefore some people might like it better, some people might like it less.
Yeah, but we need to disentangle the factual question and the legal proposition. And you were making a submission about the law, and I understand on one level the argument that subjective differences aren't enough. But one then has to stop and ask, well, why? And one answer to that might be that because being subjective, they're not susceptible of proof. And that's why I asked the question is whether the submission is that it has to be something that's measurable, because if the requirement is that it be measurable, then it would be susceptible of scientific proof. Is that the submission?
So the submission is more the way that the case was put. We don't really get to that level of measurability. I completely understand that once you make an allegation that it's negative, the issues then may arise as to does that need to be a measurable negativity. But when the case is only made on a difference, and it was clear from a trial, they weren't trying to suggest that that was a negative connotation.
Well, quite. I mean, the pleaded allegation, as you pointed out, is one of substantial difference. They don't actually plead it tastes worse, which is understandable if you take subjectivity into account. But why is it your submission that a difference is legally insufficient?
Yes, without more, simply the fact that there is some sort of difference is not sufficient to make out a case on tarnishment. And what is needed is the damage to the repute of the mark as a result of the link.
Well, that's a submission I can well understand. You need to focus on the harm, exactly so. But does it not follow that you're not looking for something that's measurable, or indeed necessarily something that's worse? What you're looking for is something that actually has a real effect.
I think that is the issue. There needs to be some sort of effect, and what they've done here is not plead what that is, or make out a case on there actually being any effect.
Well, they've pleaded the case. Whether they made it out on evidence is another matter, because what they plead is in fact substantially different in both composition and taste. These differences are perceptible to consumers, and they say that has an adverse impact on the reputation and goodwill of their brand. That's the pleading. I mean, whether it's made out of on the facts is a different matter. But you were advancing a submission to the effect that this is legally unsustainable, and I'm just trying to explore the reasons for that.
So thank you for that clarification. I think perhaps it is, if with the basis the pleading was run, perhaps it would have been open for them to then say, well, there is a difference and this has an impact. The way in which it has always, in fact, been run is effectively that there is no negative impact because there is no effect. So perhaps it doesn't really matter precisely what the legal point may be, what could have been possible hypothetically on the pleading, because in reality they've not made out any actual effect which is liable to have any damage upon the trademark. There's been no evidence that anyone thought anything negatively, even assuming that they have associated the relevant tastes and actually thought about them. And this is why, to go to the third point, it really doesn't, it is material whether the issue on the labelling was actually taken into account or not. Of course, my submission is that it wasn't pleaded, it shouldn't have been taken into account. But it's difficult to understand how really any labelling on the can has any bearing on a case which is pleaded on the basis of difference of case and position. Because it's really whether that is revealed or not to consumers in a context where for there to be any damage, they would have to have already noticed the difference themselves.
Yeah, can I come back to this not pleaded point, because that's an important point. I just want to be clear as to the parameters of it. I mean, it seems to me that at the moment, it seems to me you're clearly right about the absence of pleading. But then that leads to this question. When the point was raised at trial, presumably you objected that this was unpleaded and you obtained a ruling from the trial judge that the argument couldn't be run for that reason.
I certainly would have made the allegation that it's not pleaded. I don't think there was a specific ruling on the matter of
Well, in which case, what's your answer to Hawksworth and the Chief Constable, which says that if you don't take the objection at trial, you're deemed to have waived it?
Well, I certainly did take the objection at trial.
Right. Can you show us that?
So it's perhaps worth noting that the might necessary to look at the transcript. The allegation that there was this mislabelling only appeared in the claimant's skeleton. That's the first time it arose.
Well, indeed. And so at that point, I've no doubt you leapt up and said, "But it's not pleaded."
So I certainly noted the basis in the skeleton below where it was pleaded.
So can we let's start by looking at the skeleton, where, as you say, this point was first raised. So that's tab 11, yes?
Yes. So it starts at paragraph 84 on core bundle page 214.
Am I right in thinking that the key paragraphs are 87 and 88?
Yes, indeed, 89.
Yes, yes. So that's the first mention of this point.
And then it was certainly put to Mr. Watkins in examination at the end.
But if you'd raised the objection and got a ruling from the trial judge, it couldn't have been put to Mr. Watkins.
Well, so the way that it was put to Mr. Watkins, so I didn't raise, I can certainly say I didn't raise the point as a preliminary issue and get a ruling on it. It only really became clear when it was being put to Mr. Watkins towards the end of his cross-examination precisely where this was going. Without checking the transcript, I can't tell you exactly then how it was dealt with in closing.
in the judgment, the judge seems to think it's still a live issue, because otherwise she wouldn't have dealt with it.
Well, perhaps while the transcript's being checked to my left, I mean, the point 3 is really, it doesn't matter if it was pleaded.
But your first submission was it does matter that it wasn't pleaded, and on the face of it, that seems like a good point. As I say, subject to the question of Hawksworth and Chief Constable, and the objection was waived, but because it wasn't pursued at trial.
Well, that's obviously my primary argument, and subject to various transcripts searching to my left, and I'll come back to that. But it's immaterial given what was pleaded simply on difference of taste and composition. It's hard to see how what is actually said on a can will have really the impact that the appellants are arguing.
Yeah, just so as we're clear, because I'm not sure I quite understood the question, your answer to my last question. So to give you the opportunity fully to deal with it, what I was referring to was what the judge says in paragraph 141 of the judgment. And what she says at 141 is Thatchers further submits there is detriment to repute arising from the fact that although the sign states that the ordered products are made from premium fruit, it has no real lemon in it. And this is deceptive to consumers. And then she goes on to say she struggled to understand how Mr. Howe put the case. And then there's the reference to labelling, which we discussed yesterday. And at 142, she rejects the argument. But therefore, what I was putting to you is that the judge seems to have understood that this was an issue which she had to determine. Whereas, if it was never pleaded and the objection had been taken that it wasn't pleaded, the judge would never have said any of this because she wouldn't have thought there was anything to say in the judgment.
Well, I completely understand that's how it looks from what she said, and perhaps I can deal with it in a different way. Even though, say that the point generally could be wrong, that it was the mislabelling allegation was relevant. It was certainly not pleaded or given proper opportunity to rebut the case that it was actually deceptive. If the actual allegation of deception matters, and that was certainly not an issue to the extent that we could properly deal with it. Mr. Watkins did his best by referring to the compliance with the regulations on labelling.
Well, the judge understood that it was an allegation of deception, and she didn't say, this is not an allegation I have to deal with. Firstly, because it's not pleaded. Secondly, because it's procedurally unfair, because Aldi have been ambushed by this. And I don't think you have a respondent's notice saying that it was procedurally unfair for this point to be raised, do you?
No, there's no separate point on this. I mean, the bulk of the submissions that were taken up on this was in the judge trying to understand sort of what was being put. Could I just take 20 seconds to see if the search of the transcript next
Sure.
to me has
Sure.
produced it? So, I mean, Ms. Herrick, who was my learned junior in trial as well, also recalls it being raised, but unfortunately cannot find a specific reference to objection at trial. And I think in light of that, I'm not sure I can really take this point much further. Although I am, perhaps I could be allowed to make doubly sure over lunch that there's
Sure.
certainly no reference there.
Yes, of course.
But putting that aside, I think that the way that the wind seemed to be blowing at trial, it certainly appeared that it was not a matter which was going to be something the judge was going to find favour with. And in my submission with some reason, the logic that must be applied if the can, the labelling on the can is relevant, requires first the consumer to drink the cider, realise it tastes different, turn the can around, read the small print, see that it says lemon flavoured cider, feel that they've been deceived by Aldi, and then think worse of Thatchers.
No, I mean, I appreciate there's two different things here which you're dealing with, and I apologise if we're mixing them up. There's the pleaded allegation and then there's the subsequent allegation. But so far as the subsequent allegation is concerned, I don't understand that to be the way the point is put. The way the point is put, as the skeleton argument made tolerably clear, I believe, is that you look at the front of the Aldi can, and what you see is, in descending order, the words Taurus, cloudy, cider, lemon, and immediately under lemon, made with premium fruit. And so the allegation is that would lead the average consumer to think that it contains lemon juice. And the fact is that this is not in dispute. It does not contain lemon juice. The only relevance of the labelling is the question of whether that would be sufficient to alert the consumer to the fact that it doesn't contain lemon juice. As to which, first of all, the judge states something which is factually incorrect, because the labelling doesn't say that it doesn't contain lemon juice but only ascorbic acid and lemon flavourings. That's simply not on the label. You only find that out when you look at the recipe for the product. And the question therefore is, can the consumer deduce that from the fact that it says in small print, cloudy lemon flavoured cider? And then the next question is, if they can't deduce that, does it matter for the purposes of the Section 10.3 claim?
Well, I think my primary submission is it's unclear how any of this matters in having any reference to the Thatchers product at all.
Yeah, so your case is very simple. You say, even if it's deceptive to consumers because it leads them to believe it's got real lemon juice in it when it doesn't, that has no impact at all on Thatchers.
Well, quite. And I would just flag that the way that this ground 8 is framed, which is in the grounds of appeal, tab 1, called on to page 16. The wording of ground 8 is that the judge should have held that the differences between the taste and composition of the respective products, with the Aldi product using Ersatz flavouring in place of real lemon juice, coupled with the admittedly misleading words made from premium fruits, give rise to a real risk of tarnishment. So we'd always understood this argument to be related somehow to the actual difference in taste. If that's not how they're now running it,
Well, I agree with you. It's wrapping up what are conceptually two distinct points, but nevertheless, they're plainly complaining there, are they not, of what is described as ersatz flavouring in real lemon juice and the allegedly misleading words. I mean, admittedly, I think it's possibly putting it a bit high, but you would take issue with that, I'm sure. But leaving that aside, I mean, the thrust of the point is made, isn't it?
Yes, I mean, trying to understand what really is alleged to be the harm here has always been difficult. I think we agree ultimately what is all an issue, and I think that sort of if consumers do realise that there is an artificial flavouring, why should that have any impact on Thatchers? I mean, that's the bottom line. I suppose my bottom line submission is sort of who cares?
Yeah. And you say that's the same on both heads. So both in terms of differences of taste and on terms of the misleading nature of the Aldi label, you say even if those propositions are true, which you dispute, it doesn't matter anyway.
Yes, and even if they try and combine them together to create something that's greater than the sum of their parts, then that doesn't help them either.
Right. But so far as the second of the two allegations, what do you say about the fact that the judge has proceeded on a factually inaccurate premise? Do you simply say, well, okay, so be it, but it doesn't matter?
What precisely do you mean by the factually inaccurate premise?
What she says about the labelling. Who later discovered by reading the labelling on the back that it does not contain lemon juice but only ascorbic acid and lemon flavourings. Well, that's just wrong.
Yes, I mean, I accept that that's wrong. I don't think, given the overall issues, it's really going to matter whether what was said is specifically citric acid or flavoured lemon. If anything, it may help us in that consumers are less likely to realise that it's artificially flavoured. But really, I don't think it's something that's material, bearing in mind the points I've made.
Okay, can I just tease out that submission and see if I've understood it? I think what you're submitting is that the deception is perfect. So consumers don't know that they're being misled, and that's why that's one reason why it has no impact.
Well, yes, certainly, if that is the case, then yes. If the deception isn't perfect, then who cares, really? I think is the combined submissions I make.
Yeah.
That's everything that I wanted to say on tarnishment. I can see the time. It will take me more than a few minutes to address that.
Right, okay. We'll pause there and resume at 2 o'clock.